misinterpretation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of the federal, state, county, city, township agency present?
Glenn might want to mute your mic.
Sorry?
There's feedback.
Oh, there's feedback? Okay, I'm mute.
Thank you. This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. Second reading. This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, county, city, or township agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. Perfect. One last time. This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in appropriate manner. To eliminate all conflict and false allegations,
Where's my quarter pounder with cheese?
is apologize. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, county, city, or township agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, state your name, and say your name and state your position. Apologies for that, and I'm going to end that with a short prayer. Oh, Holy Father, bless our meeting with eyes to see and ears to hear the messages and information being presented with an open and caring and compassionate heart for all our brothers and sisters to see, as it shall be done. Take it away, Glenn.
Okay, well, so what happened is we were doing common law court judgments, and there was someone that hyped up a bunch of information, Republic of Texas common law court judgments, and someone took offense. I think it was more or less a bunch of hype, and they were looking.
Glenn, you're muted, I think.
Okay, I'll let you have that one. Here I was rattling on, and I was muted. Okay, thank you. Anyways, so what happened is we were doing common law court judgments, and the state of Texas doesn't have anything to say about common law court judgments, but because it's a foreign jurisdiction, okay? You got to understand that under Title 18, United States Code, Section 11, the Republic of Texas is a foreign government. And so we were doing, and this was actually about a year ago, we needed to introduce them into the de facto courts because what we want to do is get people out of jail. And so we did that. We did actually my case that I filed that's now in the Court of Appeals. That one is has a common law court judgment attached to it. So I'm curious to see what they do, but they're probably not going to hear anything for probably, maybe 6 months at least. So, we'll see what happens with that. Actually, I'm preparing a emergency petition to the Supreme Court, and I'll probably start working on that right away. I almost had it done before, and so I'll probably finish it up and file it. But anyway, so we were doing that, and then when I was in that federal case, I made some statements about that weren't intended to be threatening, but that were intended to show the gravity of the situation. And, they took them wrong. Of course, it's an excuse. They use that as an excuse to go and assault you. So what they did is they charged me with 3 felonies, terrorism, terroristic threat, and organized criminal activity. And one was a class 2 felony, and then there was class 3 felonies. There was 3 of them anyways. And they arrested me in the parking lot at the hotel I was at in Albuquerque. And I had, I really think this is my destiny. I really feel that because I had deja vu big time when I was in jail in Albuquerque. It's like I had been there before. And, I don't know how many of you know what deja vu is, but that's when you had that feeling you were there before. And what happens is people actually are there, but it's in a dream. And that's universe. Sometimes when you dream, you time travel, and it's universe's way of telling you you're on the right path. And I had deja vu there. And then when I was here in Texas, same thing. And there was just all sorts of divine intervention. I'm telling you, major divine intervention. So, when I was here in Texas, they extradited me. Actually, they had to extradite me, and I waived it. But everything they gave me to sign, I signed without prejudice. And we're going to go through, I'm going to start with this motion for an identity hearing because this is like really powerful. I've converted it into a Word file and I'll upload it to the group. And anytime you get in an issue with the courts, you got to do this, okay? You absolutely have to do this, and it'll probably make it all go away because they don't have a shred of authority. It's the only thing they can deal with is the fiction. And this is basically getting them to admit that you're a living man or woman. So I got to tell you that this is probably the single most important thing to do. The second most important thing to do, and you should do it all the time, is sign everything without prejudice. I signed everything, and I'll show some of those documents that I signed, and you'll see where I have the without prejudice. I don't put a signature there. I just put it without prejudice. And that is like, that means what happens is you're reserving your common law rights. They're assaulting you. Anytime they want a signature, it's a contract. That's why they want the signature. It's a contract. If you refuse, then they'll just put on it refused and you signed it. And so you cannot do that. You have to put something. And so that's why you just print without prejudice. What that's saying is you're reserving your common law rights. And under common law, you have a right not to be compelled to perform under a contract you haven't knowingly, willingly, intentionally agreed to. So you're saying basically there's no contract here. And so it's the best thing. I've signed bonds that way. I've signed plea bargains. I had a judge sit there and watch me put it without prejudice on a plea bargain. and it was no big deal. I signed all sorts of stuff. Everything they gave me, I put it without prejudice on it. So what happens when you do that is they are submitting that paperwork that you sign to the Treasury, and the Treasury is paying them. And when you put it without prejudice, the Treasury won't pay them. And so now it's got to come out of county funds. And so they lose interest real quick when they have to start paying for that shit. And so you got to understand that. I mean, that's so powerful, is just put a simple without prejudice on everything. I was doing it last time I was in there, and the little pad that they give you, it's all electronic. the little pad to put the digital signature on there wasn't big enough. I had trouble fitting a without prejudice in there. And now they're all nice and big. It's like they saw that I was having trouble doing that, and so they made them all nice and big. So there's lots of room for a without prejudice there. And so that's the two most important things you can do is without prejudice and an identity hearing. And we're going to go through that argument here right now. And I just can't tell you how important this is, just absolutely critical. And I'll tell you what happened after we get through all this stuff, or I'll probably tell you in the process. Anyways, it's always without prejudice. They don't get paid for it when you do that, and that really screws them up. Anyway, so let's start doing this identity hearing. This is the one that I actually wrote. Okay. Oh, and what happened is when I got to Texas, okay, first of all, I mean, there's just major stuff that's going on here. There was a U.S. Marshal that picked me up and brought me from Albuquerque to Texas. And we didn't go in some sort of a prisoner aircraft. We flew commercial. And he had a hoodie because I was in handcuffs, but the hoodie covered up the handcuffs, so you couldn't see them, the handcuffs or anything. It just like I was walking down the street with my hands in front of me. And so it was he wanted to keep it nice, and he didn't want anybody messing with getting involved in our business. And so I appreciated that. And there was no direct flights from Albuquerque to Fort Worth. And so we flew to Houston, and then he rented a truck and we drove in the truck. And so we had lots of time to talk, and I was educating him, and he was quite interested. So anyways, so then when I got here to Fort Worth, they put you through a booking process. And one of the things that they ask you is if you want to be a trustee. Now, the kind of trustee that they're talking about is someone that like mops the floor and sweeps up and does cleaning and all of that stuff, you know. And so I told them not particularly. Anyways, they put me down as a trustee, and that turned out to be major advantage. It's basically slave labor, and I wasn't too excited about that. But you know, in prison, food is a commodity because the food is lousy and there's not much of it. And you know, I figured I lost a bunch of weight. I was when they picked me up, I was 256 pounds, and now I'm 220 pounds. And so I lost like 35 pounds. And I'd like to keep losing weight. So we'll see what happens. Hopefully I do. I wanted to get down around, you know, under 200 pounds, maybe 180. 180 is my ideal weight for my height. So anyways, I lost a bunch of weight. And so it wasn't, you know, not eating that food. It was garbage. It was mystery meat. You didn't know what kind of meat. So I refused to eat the mystery meat. And the vegetables that they give you are boiled. And so there's all the goodness is boiled out of them. And so, I mean, but I did eat the vegetables. Anyway, so that's I think I lost weight. They were also doing they were taking blood pressure all the time, and I think that was just a scam to peddle their pharmaceuticals. Matter of fact, I filed a grievance on about the day before I left about the forced medical experiments. So it's a war crime. Okay, you got to understand, everything is war crimes. So anyways, so this is the motion for, what happened also is, so they made me a trustee, right? And they put me in this pod. They have these pods, okay? Like in the, there's in Fort Worth, in the county jail, there's 3,000 people they have in there. People don't realize how many people are kept in jail. And that's just in the Fort Worth County Jail. Who knows what with the cities and all that other stuff. There's 3,000 people in the Fort Worth County Jail. What they did was, so there's the building is like 13 floors. And on one, I was on the 8th floor, and there's 4 pods on the floor. And each pod has 12 cells with 6 people in each one. That's 72. And so I was in this one with trustees, and what happened is I went in there. That they assigned me a cell, and it was a bunk bed, and it was quite high, and there was no ladder to get up to the top bunk. And I said, I'm an old guy, and I'm afraid I might hurt myself getting up in this bed. And so they went and put me in a different pod. And this is where the divine intervention came in, I'm telling you, because they put me in a different pod, and they put me in a cell where the only trustees in the whole jail that go to the law library were in my cell. So I was talking to these guys and networking and sharing ideas and doing all sorts of stuff. I told them I was a senator with the Republic of Texas, and all these guys would be saying, "Hey, Senator, how's it going, Senator?" It was half bearable. What happened is they went and my bond was $500,000, and they charged me with these 3 felonies, and then the bond restrictions. They wanted a GPS ankle monitor. They wanted home confinement. I couldn't leave home if I did get a bond. All sorts of crap. And so I figured, well, I basically resigned myself to staying there for a while. And then what happened is there was an attorney showed up one day, and I don't like attorneys. But I wasn't opposed to like having them plea bargain the thing. And I told the attorney, I said, the attorney offered to plea bargain it. And I said, okay, I'll accept your offer. But the deal is that I want time served. I want a misdemeanor, and I want no probation. And that was the only criteria that I gave her. It was a lady. And she said, okay. And then she disappeared for about 3 weeks. And then I was in this, and I didn't hear a peep out of anybody. I tried to call. They didn't answer the phone calls. I mean, I sent 2 letters, and this identity hearing was in the first letter that I sent her. And so let's go through this right now. And so the guys in the law library, I never did work in the law library, although I was on the list. There was 6 people in that cell, and only 4 of them went to the law library. And so I had to wait until someone left, and someone actually did leave, but the law library has to request someone. But that was the only cell in the whole jail where they went to the law library. So I was actually the guys that went in there. I was again, food's a commodity. So you could buy stuff on the commissary like a soup, and you give them a soup, and it costs you $1, and they'll do all sorts of stuff for you. So anyways, and I bought paper, and I bought a pen, and because I had like $160 in my wallet when they arrested me. So there was lots of money, and then plus I had some people put some more in there. And so I there was no problem with money, and I'd buy it through the commissary, and it worked out pretty good. So then this is the motion for an identity hearing. I sent a letter to this was the first one. It was on the 25th of, it was on the 20, I think it was around the 25th. So, and also this another thing is, because these guys were in the law library, I'd prepare this stuff, and then they would take it down and make copies for me. So I got copies of everything, and the copies were free. And so I never did make it to the law library, but I was on the list, and I was probably like the next one to go there. But then after 3 weeks, the lawyer shows up and says that the case has been dismissed. And so, I didn't argue with that. Anyways, and so it wasn't, they didn't drop the charges. They dismissed the charges, 3 felonies. Anyways, so they were, they were trying, it was political. Okay. Matter of fact, I was preparing a war crimes complaint for taking reprisals against me for my political beliefs. And I was going to actually remove the case into federal court and as a war crime, as a counterclaim for war crimes. And but I didn't have to. And so I'm still probably, what I'm going to do is go down to the district attorney now that they dismissed it. Okay, then they're going to be more interested in making this problem go away because they caused me a lot of damage, and I think I can probably get a settlement out of them. But so we'll see. We'll see. You never know. This is for the Republic of Texas, and so this is when this happened. I just had this feeling that this is going to be the most wonderful thing that's happened to us in a long time. And I just had the feeling this is wonderful. I am so glad. And I'll tell you, I really had that feeling. And I still think it's just going to be, there's going to be wonderful things that are going to come out of this. Anyways, so I did, this was the first thing that I sent to that lawyer is a motion for an identity hearing and a motion to quash the warrant. And so we'll go through that one next. 3 warrants, and I got copies of the warrants here, and we'll go through why they need to be quashed. Anyways, so this is the motion for an identity hearing. And so now to the Honorable Judge of the Court comes now the respondent in error requesting an identity hearing for the following reasons. The respondent in error needs to establish that he fails to be a minor estate, 31 CFR 363.6, and fails to be lost at sea, but is a living man who walks among us on the land. The Pope's minor estate, 31 CFR 363.6, falls under the Pope's Roman canon law of trusts and is property and a thing, and has no rights. Paraphrasing 31 CFR 363.6, a minor is anyone under the age of 18 years and can be anyone over the age of 18 years who has not taken control of the securities in their Treasury direct account. And an entity is a trust, corporation, limited liability company, or a minor estate. And so the minor estate falls under the Commerce Clause, Article 1, Section 8, Clause 3. And so notice that I put a footer here for a motion for an identity hearing, and I also put it at the top, continued from page 1. I want to make sure that there's no confusion about which page goes where, because they won't let you use staples there. Okay, so I got to make absolutely clear which page, which sequence they're in. Anyways, so under the Commerce Clause, Article 1, Section 8, Clause 3, paraphrasing from the U.S. Supreme Court National Mutual Insurance Company versus Tidewater Transfer Company, 1948, the boundaries of the District of Columbia expand as necessary throughout the states of the Union with a plenary jurisdiction for U.S. citizens. Plenary means it's a dictatorship. Okay, that's D.C., which is in violation of Article 1, Section 8, Clause 17, a maximum of 10 miles square for a man. All the evidence the plaintiffs have introduced against the respondent in error is evidence of the minor estate, 31 CFR 363.6, name, date of birth, social security number, and are hearsay evidence from a hearsay database that the respondent in error failed to introduce. Therefore, it's inadmissible. The respondent in error did sign a waiver of extradition, but it was signed without prejudice, and the respondent in error was not given the opportunity to make any changes to the text. Therefore, the without prejudice endorsement reserves common law rights, which means there's no contract and no evidence admitted. The plaintiffs have failed to produce a bona fide contract that the respondent in error agreed to be the minor estate or subject to the Pope or Roman canon law. Therefore, this court is required to presume no such contract exists, and that's true, okay? If there's no contract in the evidence, then the court has to presume there is no contract. Will Livingston ratified the U.S. Constitution for New Jersey, 1787, is the respondent in error's fourth great uncle, which means the respondent in error has right of blood, and the maxim of law says no civil law can violate right of blood. And all the laws of Congress after the 1871 Municipal Corporation for the District of Columbia was created by Congress are all civil laws, which includes the minor estate, 31 CFR 363.6, which was introduced in the year 1901 with the Code of Law for the District of Columbia, 31 Stat, the legal estate to be the Sestike use, and use is short for usufruct under Roman canon law, and the dissenting opinion of the U.S. Supreme Court case Downs versus Bidwell said two national governments exist, One operates under the Constitution with all its restrictions, and the other is operated by Congress outside and independently of that instrument. The respondent in error respectfully requires this court to declare the respondent in error a living man that fails to be a minor estate, 31 CFR 363.6, and fails to be lost at sea, but is alive and walking among us on the land. And that's it. Respectfully submitted under penalty of perjury. A living man, GlennWinningham Fern, a living man with full responsibility for my actions under God's law as found in the Holy Bible. And then there's an affidavit of service here. So that's it for the affidavit or the motion for an identity hearing.
Well, see, I was told during your stay that you were going to see the magistrate on the 25th. And so I called after that, and I was told that you weren't able to see the magistrate. But I was assured that you were being treated correctly and that you were doing okay, because I was very concerned about, the treatment that you were getting. I was asking if, you wanted us to do any health checks so that they knew that we knew what was going on, and we wanted to support you from where we could, right? So,
well, and that's appreciated for sure, because that holds our feet to the fire.
Yeah, but it just seemed like, you were handling everything, and I was told you were acting as a trustee, which worried me, but you were in the law library every day able to work on your cases. So that kind of put me, at ease, right? And of course, it was a good relief to be able to let all the important folks here know that you were okay. So I
Yeah,
appreciate it.
so I wasn't actually in the law library, but I had contact there. And there was only 2 days a week when the law library trustees go there. And but I was they had me doing other work. I do, they call it tray running, which is, they gotta move those trays. The kitchen is underneath, is 3 blocks away. There's 3 buildings, and each one is about a block. And so there's the kitchen's 3 blocks away, and so it's all done underground, and you have these carts, and you have to move them from some of them the 3 blocks. And so there's about 12 of us that go down there, and we run these carts all over the place. And we did lunch. There was another pod that did dinner, and I guess another pod did breakfast, but we did lunch. And so the but I appreciate you following up. I didn't. What happened is, when that lawyer showed up, then the 25th, I would have gone to meet with the judge. It would have been basically the lawyer telling the judge that I couldn't, that I didn't have a lawyer, and I'd have to do it on my own. And it worked out pretty good, because the lawyer went and got the thing dismissed. And so that worked out good. Anyways, so it worked out good. I was there about 40 days, 43 days or something like that, 6 weeks. And they dismissed it, and so it's dismissed. They didn't drop the charges. The charges were dismissed. And 3 felonies. I can't imagine anybody getting 3 felonies dropped like that, but or not dropped, dismissed. And so now that they dismissed them, then they're liable. Okay. And so that's why I'm going to go down there and talk to them. And right now I just rented a car, and I have to go to New Mexico and get my car. And so I got a friend going with me on Monday. Sunday night, actually. We're going to leave Sunday night and drive to Albuquerque and get my car. And there's going to be about $1,000 in storage and all that. But that's not bad compared to what it could be. It's $16 a day, which around here I think it'd cost like about $40 a day. Anyways, so I'll be going there and getting my car back. And the important stuff is I got stuff in it that I want to get back. So anyways, I'll be leaving Sunday night to get my car, and then we'll take it from there. So I did that motion to for an identity hearing, and then this motion to quash the warrants, and we'll see the warrants at the end here, what they look like, and why they're illegal and unconstitutional. And so let's go ahead and start with this. I appreciate you following up on it, Lori. That's great, because that kind of lets them know that there's people concerned, and they got to be careful. It makes them have to be careful about what they're doing. So this motion to quash the warrants is move this court to quash the warrants in the above entitled matter for the following reasons. So then I started off with some definitions. When a superior court of general jurisdiction, they're all superior courts of general jurisdiction, becomes involved with anything in derogation of common law, it becomes quad hoc for the purpose of this proceeding only, an inferior court of limited jurisdiction. And that's taken from Corpus Juris Secundum, Book 20, Section 7, Courts. U.S. Constitution, Article 3 says that all judges holding office during good behavior, which means they're required to be neutral and unbiased. And when they fail to be neutral and unbiased, they fail to be in good behavior, but are in bad behavior. A bill of attainder is defined by the U.S. Supreme Court as paraphrased. A legislative act, no matter what their form, that targets a named individual or easily identifiable group in such a way as to inflict punishment without a judicial trial. So those warrants, I can show that they're actually a bill of attainder. Actually, it's called a bill of pains and penalties, because a bill of attainder is the death sentence, and the bill of pains and penalties is anything less than death, and they're both unconstitutional under the bill of attainder clauses of the Constitution. Fictions of law were, quote, created by the Roman praetors under the pretense of doing equity, and are a, quote, legislative usurpation of the bench, because the legislators command. And that's Bouvier's Law Dictionary, 1856 edition. Civil law, Roman civil law are convertible phrases with municipal law. And that's Black's Law Dictionary, 4th edition. Why do you think all these municipal corporations are all over the place? It's because it's the Pope, it's the Vatican. And that's exactly why. A minor estate, paraphrased, a minor is anyone under the age of 18 years, and it can be anyone over the age of 18 years who's failed to take control of the securities in their Treasury Direct account. Did you know you have a Treasury Direct account? You do. And there's securities in it. Federal Reserve notes are securities. Entity is a trust, corporation, limited liability company, or a minor estate. So then those are the definitions. Now we'll go into the arguments. So the warrants name a fiction of law and a date of birth tied to the minor estate. And that's 31 CFR 363.6 under the Commerce Clause, which is Article 1, Section 8, Clause 3. In violation of Article 1, Section 8, Clause 17, a maximum of 10 miles square, and fails to have a court seal as required by the Authentication Act, which means the warrants fail to be authentic. The warrants are each bills of attainder because they're legislative acts commanding the fiction of law, minor estate, under Roman law be arrested in derogation of common law, because at common law a proper name is never spelt in all block capital letters, with the date of birth which precipitated the respondent in error, the named individual, being punished with an arrest, and the judge of the 45th District Court, operating in his private capacity, signed it, no judicial signature, which is why there's no court seal, because it's not issued by a court, which also means the warrants fail to be authentic warrants, but are a fraud. Only an Article 3 court can make decisions about life, liberty, or property, which means the warrants are unconstitutional and void. The plaintiff has introduced no evidence that the respondent in error is in a contract waiving any rights, and this court is required to presume no such contracts exist. The only evidence introduced by the plaintiff is hearsay evidence of name, date of birth, and social security number, none of which was admitted by the respondent in error, and it was obtained with an illegal search in violation of Article 4 and Amendment because there's no search warrant. Therefore, the hearsay evidence is inadmissible. Will Livingston ratified the U.S. Constitution for New Jersey, 1787, is the fourth great uncle of the respondent in error, which means the respondent in error is posterity, as found in the preamble to the Constitution, which means the respondent in error has right of blood, and the maxim of law says no civil law can violate right of blood, and all the laws of Congress are civil laws after 1861, when the southern states walked out of Congress and Congress ceased to have a quorum to conduct business. And Lincoln ordered Congress to reconvene under executive authority with Executive Order Number 1 on the 15th of April, 1861, and Congress has been operating under executive authority ever since. And the year 1871, Congress authorized a municipal corporation under Roman law to operate in the District of Columbia, and all the laws of Congress after the year 1871 are civil laws, and all the laws of Texas after the Civil War are civil laws, which includes the minor estate, 31 CFR 363.6, and the Texas Penal Code, because they're all Roman law, and the minor estate, 31 CFR 363.6, was brought into the United States with the Code of Law for the District of Columbia at 31 Stat in the year 1901, with the legal estate to be the sestike jus. And jus is short for usufruct under Roman law, which is a type of a trust under Roman law from the Pope. And the Texas Penal Code provides penalties for non-compliance with quasi-contract agreements under a sumpsit that only apply to fictions of law under Roman law. The U.S. Constitution, Article 6, Clause 2, says, paraphrased, this Constitution and all laws pursuant thereto are the supreme law of the land, and all judges shall be bound thereby, anything in the laws or Constitution of any state to the contrary notwithstanding. And the Authentication Act is the very first act of Congress and requires a court seal and judge's signature for any court document to be authentic. Therefore, these warrants fail to be authentic, which means they're a fraud, and everything that flows from a fraud is also a fraud. True certified copies of each warrant are attached hereto, all of each of which are incorporated herein by reference in their entirety. During the arrest, the respondent in error heard one of the officers say, call a name and tell them I need those warrants, which means the respondent in error was arrested based on hearsay evidence, hearsay computer entry, because they have a duty to show their authority to make the arrest, and they failed to have warrants in their possession, and in the event the respondent in error had exercised his right to resist their unlawful arrest with lethal force if necessary, see U.S. versus Amistad, they would have killed the respondent in error. The warrants themselves show they were faxed from the header August 4th, 2025, 10:37 p.m. after the arrest, which took place around 9 p.m. This defect is not curable because putting a court seal on the warrants after the fact would not change its character from a bill of attainder or change the fact that the arrest had already taken place and would be fabricating evidence, which is a felony. The respondent in error requires this court to quash the warrants and dismiss this case with prejudice and order the respondent in error released immediately. And so that's 13 pages. What's this?
Let me see how you signed that. You did sign that.
You did that.
Oh, this is the affidavit of fact. Okay, so I'm going to delete that page. Okay. Right. And now here's the warrant. See here, GlennWinningham Fern in all block capital letters. That is a legislative act, okay? Because that judges are supposed to be neutral and unbiased. And when he's putting that there like that, he's commanding, okay? That's a fiction of law, and he knows that fiction of law doesn't exist, and yet he's putting it on there anyways, and he's signing it down here. But notice there's no court seal. And so that makes that a bill of attainder, a bill of pains and penalties, actually, because he's the judge normally of the 45th District Court, but he's signing it in his private capacity because there's no court seal. And this is, see what, because I had access to the law library, this is a verification of unsworn declaration instead of having a notary, because normally you get a notary to certify documents. And you can't admit evidence unless it's certified. A document has to be certified. And so I, GlennWinningham Fern, hereby certify this is a true copy of what I was given by the New Mexico Public Defenders as justification for my arrest by the New Mexico State Police. And so this is a terroristic threat, third-degree felony, and then the document to certify that it's certified. And then here's the one. Sorry.
Please, could you minimize that side column to expand your document? I would like to be able to see these words. This is really helping me so much. Thank you.
Mary is going to upload it after he finishes. Okay.
Thank you.
I'll upload the file, this file, and the Word file. Okay, so you can take the Word file and manipulate it. But notice at the top, see right here, August 4th, that's the fax header, 10:34 p.m., right? And the arrest took place at 9 p.m. And so they didn't have these warrants, and so it's an unlawful arrest. And it's color of law, it's multiple felonies going on here, okay? And this is another certification, and this is the verification again. And then here's the third warrant, engaging in organized criminal activity. It's a legislative act, and because the judge is either a judge or a legislator, okay, one or the other, can't be both, and so in this case the judge is acting as a legislator. So it's a legislative act that's against a named individual, me, which they're naming the minor estate, okay, and in such a way as to punish me without a judicial trial. And so then that's the certification again. I'm not sure how to close this thing. Let's see. Oh, there we go. Okay.
Thank you.
So these are the warrants, and what I can do is I'll show you the action that they brought in New Mexico. I'm preparing a war crimes complaint, and I'm just about done with it. This motion to quash the warrants, I think I sent this with the second letter that I sent to the attorney on the 2nd of September. September. There was also another document, let me think. Oh, an affidavit of fact. Let's go through that affidavit of fact, because have I got that opened? No, I don't. So I need to open it. We'll go through the affidavit of fact, because I'll go through, and this is called confession and avoidance, okay? Where you basically say, yeah, I did what you're saying, but I wasn't trying to do that. I was trying to do something else. And so you avoid the charges, because with any criminal charges, there has to be intent. So this is the affidavit, and this went with the first one. This went with the first letter to the attorney. And so this is, again, affidavit of fact. I, GlennWinningham Fern, do hereby affirm the following facts and evidence to be true to the best of my knowledge and belief. I affirm that I'm competent to act in the lawful matters herein, and if called to testify, shall so state. I affirm I have standing and first-hand knowledge of the facts and evidence herein. I affirm that I have no first-hand knowledge of my birth, or any evidence of a birth date is hearsay evidence, but I do remember finishing high school in the year 1975, more than 50 years ago. Therefore, I'm well past the age of majority. So the purpose of the birth date, the only time they ever want to know a date of birth is they need to know that you're over 18, okay? So don't ever give them a birth date because they need that for the minor estate. You tell them, well, I don't remember. I have no first-hand knowledge of that, but I do remember finishing high school in 1975 or 1990 or whatever, showing that you're more than, 18 years old. And so I affirm that I have never in my life breached the peace, but the military police in this country, acting under the Pope's Roman canon law, breach the peace on a routine basis. I affirm that the statements complained about in the above entitled matter that were made in the Fort Worth federal lawsuit case 424 CV 0881 were not meant to be threats of any kind, and I do not say I will do anything at any time, but were made to express the gravity of the situation because I have never in my life breached the peace. I affirm that the Fort Worth federal lawsuit is now in appeals, and the state of Texas actors are interfering with my right to appeal because the appellees are trying to get it dismissed, and they have obstructed my ability to respond and prosecute the appeal, and this case is based on an undecided matter. I affirm that I am currently a senator with the Republic of Texas. I affirm that as a senator with the Republic of Texas, I have immunity from public statements like those in the Fort Worth federal lawsuit because of the Articles of Confederation provide for immunity. I affirm that I got involved with the Republic of Texas in the year 2007. So I go through and I explain my history, okay? So they know that I'm not new to the Republic of Texas. I've been doing it for like 20 years. When the president of the Republic of Texas suggested I run for Congress, which I did. And then he suggested I run for Speaker of the House of Representatives, which I did. And I was Speaker for about 18 months. I affirm that during that time I was Speaker, several people approached me on different occasions wanting to set up a militia. And I told them that we were not opposed to a natural disaster response team to support local authorities in the event of a natural disaster or local emergency, but we would not be setting up a militia because we do not want to appear to be a threat of any kind. I affirmed that in the year 2008, and so I did that, and that's all true. I did that to show that I'm not trying to threaten anybody. I affirm that in the year, and that I have a history of not trying to threaten anybody. I affirm that in the year 2008, I left Texas, resigned the House of Representatives to go to work in White Plains, New York for about 18 months. I affirmed that while I was in New York, the president of the Republic of Texas called me to see if I was interested in opening up negotiations with the Russian Federation for a treaty of peace and recognition, and I thought it would be a great idea. I affirmed that I was provided with a commission as a charge d'affaires, but was never given the final go-ahead to make contact with the Russian embassy. I affirm that since that time I have enjoyed lifetime diplomatic immunity status under international law as a protected person equivalent to an ambassador or executive officer of a foreign government. I affirm that I continued to maintain my contracts with the peaceful Republic of Texas, and in the year 2012 I returned to Texas and ran for the House of Representatives and then the Senate, and I'm currently in my second term with the Senate. I affirmed that in the year 2024, we wanted to establish common law courts to offer people a common law remedy for issues they may be having. I affirmed that we got a known successful common law case that was upheld by the 14th District Court in Dallas, case number 95-07735 on the 19th of September, 1995, called Ayabello Corporation, WFAA TV, and versus Johnny Johnson and Lakeview Developers, and use it as a template. I affirmed that we organized a common law Republic of Texas court, got seals for the court, the same as the WFAA TV case, and followed that pattern in detail for about 6 cases, one of them being for Kenneth Ouimet. I affirmed that we needed to introduce them into the state of Texas courts to try to get some feedback because 30 years had passed from the WFAA case, and we needed to know if we needed to make adjustments or changes to how we did it because we wanted them to be recognized so we could help people. I affirmed that under 18 U.S.C. Section 11, it's not 111, it's Section 11, the Republic of Texas is a foreign government, whether recognized or not. Therefore, our judgments are foreign judgments, and the state of Texas could simply refuse to recognize them but we wanted to work with the state of Texas to make them acceptable. I affirm that we introduced 2 of the common law court judgments into the United States courts, one for Kenneth Ouimet and one for me, with the Fort Worth case previously mentioned. I affirm that our rationale for doing this is U.S. Supreme Court case Hale versus Henkel that said common law is the law of the land and has always been here, and Ex parte Milligan that said that the military courts are required to step down when the people step forward with common law courts, and is found in the Judiciary Act of 1792, 1 Stat 77, that said common law is the rule of decision everywhere above the high water mark and past the first bridge across any navigable river, except for the District of Columbia as found in Article 1, Section 8, Clause 17. But that because of the Pope's minor estate, 31 CFR 363.6, all courts presume trust law, which is part of the Pope's Roman canon law. I affirm that we in the Republic of Texas had no intention to make any threats of any kind and extend our deepest apologies to anyone who may have felt threatened, and any constructive criticism to what exactly made them feel threatened, we will gladly make corrections to fix it. I affirm that because Kenneth Ouimet pled guilty in his plea bargain, he nullified his common law judgment, and it should be vacated, and we are prepared to do that at the earliest opportunity. I affirm that as a senator, I can say with authority that we in the Republic of Texas want a peaceful, friendly relationship with the state of Texas. We know the state of Texas does not recognize the Republic of Texas, and we're not asking for recognition, but we can still build trust. The foregoing is submitted as the truth, the whole truth, and nothing but the truth before God of the Holy Bible, angels, and anyone who reads this as a witness, all of which is submitted under penalty of perjury, 28 U.S.C. 1746-1. And then with full living man, with full responsibility under God's laws found in the Holy Bible and no other. So that's the, and now let me show you another document that that was introduced in New Mexico, because this is kind of interesting. This is, well, here, let's look at the waiver of extradition. This is the waiver of extradition. And this is how I signed. I put without prejudice. So look here. This is the waiver of extradition. Notice the name spelled in upper and lowercase, okay? They knew how to do it. And notice why I put without prejudice right here. And they asked me when I was doing that, is that your signature? And I said, it absolutely is for this purpose. And so, and there's the judge's signature right there. And so, that was interesting because I originally started to assert the extradition, but they told me I could be in jail with no opportunity for bail up to 4 months. And so I'd have to stay in jail. And I figured, well, you know, I think I need to go back to Texas and deal with this because, you know, I don't want to be in jail for 4 months. Anyways, and so I was out a lot less than 4 months. I was, you know, in there for about 6 weeks. But when I went and I started out with, I was going to assert extradition. And when I decided to change it to waive the extradition, the judge said that because I was doing this, I was not forcing them to prove that I was the exact person named in those warrants. And they were 100% right. Okay, and the judge knew that was a fraud, and that was the impression I had is the judge knew that thing was a fraud, and that I could I could have, if I would have fought the extradition, I probably could have quashed those warrants, and but anyways, you live and learn, right? So I did them all three. There's 3 of them because there's 3 warrants that they arrested me on. See, again, without prejudice, and I don't put a signature. That's the public attorney's, the public defender's phone number that he put there. And again, without prejudice. So, and then also another document. Let me see if I can find it here. There we go. Right. Whoops. Okay, so this is the fugitive complaint that had been submitted into the court in New Mexico. See, state of New Mexico, county of Bernalillo. And so this got the name spelt in all block capital letters, had a date of birth, had a social security number. I redacted these. But so the point is, if you look here, it says the time when the arrest took place, right here. Defendant was arrested at 21:16 hours. That's 9:16. And so remember on the facts, it showed that they received the warrants at 10:34. And so that's showing they didn't have the warrants. And so the arrest was color of law. So they violated my rights. This is proof that they violated my rights under the color of law. Right here, it's proof. And so that's a felony. So anyways, now, so I signed absolutely everything they gave me. I just put it without prejudice there is all I did. So let's go through now the, let's see here. I got the affidavit of fact, the motion to quash the warrants. Oh, the motion to suppress the hearsay evidence. This is one I was preparing. And I never did get it to the lawyer. But again, this is the arguments that you have to do. You have to challenge everything. If you don't challenge it, then you admit it. Okay? And you have to understand that. So this is the motion that I had prepared this, and I never did get it to the lawyer. But it was ready to go. I just need to make copies. So it's a motion to suppress the hearsay evidence, and I'll put Word files of these and upload them to the group. And these are taken from forms, standard forms that you can get in the law library. Although the arguments and stuff, they're not in those forms, okay? But at least it'll get you started with, putting everything up here, the heading, and to the honorable judge comes now the respondent in error, moving the court to suppress the hearsay evidence for the following reasons. The plaintiffs have introduced the hearsay evidence of name, date of birth, and social security number, which the respondent in error has failed to introduce or admit and is inadmissible. The hearsay evidence was obtained from an illegal search and seizure of a government database, which is itself hearsay, in violation of Article 4 and Amendment. The respondent in error neither admits nor denies the validity of any of the hearsay evidence except to say that it's evidence of a minor estate. And this is actually a quote from that. I went and we had a tablet. They gave us a tablet, and we could look up a lot of stuff. And so this is actually a quote from that tablet. It says a minor means an individual under the age of 18 years. The term minor is also used to refer to an individual who's attained the age of 18 years, but has not yet taken control of the securities contained in his or her minor account. That's a quote, direct quote from that 31 CFR 363.6, which falls under the Commerce Clause, Article 1, Section 8, Clause 3, because 31 CFR 363.6 further defines an entity. An entity means any owner of a Treasury Direct account that's not an individual. Entity is a sole proprietorship, partnership, corporation, limited liability company, or professional limited liability company, trust, the estate of a decedent, or the estate of a living person such as an incompetent or a minor. And the minor estate is a type of a trust which falls under the Pope's Roman law, which is a violation of Article 1, Section 8, Clause 17, a maximum of 10 miles square, because under the Commerce Clause, as summarized from the Supreme Court case National Mutual Insurance Company versus Tidewater Transfer Company, 1948, the boundaries of the District of Columbia expand as necessary throughout the states of the Union with a plenary jurisdiction for U.S. citizens. And the respondent in error fails to be a minor estate, but is a man living on the land that fails to be lost at sea. The minor estate, see, if I went and got a ruling on that identity hearing, then I could actually quote that in here. Anyways, the minor estate is owned by the United States federal government pursuant to the U.S. Constitution, Article 4, Section 3, Article 4, Clause 3, which says, the Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or the property belonging to the United States. Therefore, regulations, all regulations. Now, I'm not sure that I would put this in. This is kind of a mixed, because if it's an illegal search and seizure, you're basically saying that it's your property that's in the government database. But here I'm saying it's the government's property, and so then they might be able to say, well, if it's the government's property, then we can go ahead and search it. And so you got to be careful about some of this. But so I'm not sure at this point. I'm still have mixed feelings about whether I want to put this in there or not. Anyways, the Congress shall have power to dispose.
Have an interest in that?
Sorry?
What about you have an interest in that?
I do. Yeah, that's true. And so I could make that argument. Anyways, the Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. So if it's in the regulations, it's property belonging to the United States. Therefore, all regulations are for property belonging to the United States government. The search of government databases was warrantless and unreasonable and produced government property which fails to be the respondent in error, and the plaintiff has failed to produce a bona fide contract with the government involving the respondent in error. Therefore, the hearsay evidence should be suppressed, all of which is submitted respectfully under penalty of perjury pursuant to 28 U.S.C. 1746-1. This one never did make it to, but see, I put the footer and the header on every page, so there's no confusion about which page is where and all that stuff. And that's a lot of that is because they don't let you, when you're in jail, you can't use staples. There's, I guess they're worried about using it as a weapon or something. I don't know. Anyways, so does anybody have any questions? I'm going to go ahead and upload these to my group, and then if anybody has any questions, I'll take questions.
If no one has any
What was
questions.
the latitude? Right. Okay.
Yeah, I have so many questions.
All right.
If anyone else is not speaking.
No, Big Blue Ocean was first, so go ahead, please.
I apologize.
Well, Glenn, what was the latitude? Are you getting feedback?
I'm
What was
not, but maybe I need to mute myself.
What was what was the latitude and longitude where they claimed in the United States where they claimed the offense occurred? Have we nailed down the latitude and longitude within the United States where the offense occurred?
You know, I never saw anything like that.
It's an impossibility.
Okay, so what's that got to do with anything?
It's outside the jurisdiction. The crime committed outside. They claim a crime was committed in the United States. What's the latitude and longitude where the offense occurred?
Well, you know, that's an interesting argument, but that's kind of like difficult to prove. It may not be that difficult to prove, but it's still a technical argument that is in order. If you want to make an argument, you gotta be able to prove it and argue it. You know what I mean?
I'm not arguing it. I'm making a question to them that if the offense occurred in the United States, what was the latitude and longitude? They can't answer the question because the United States is a fiction and doesn't have latitude and longitude.
Oh, I agree. Yeah, that's an interesting point. But again, you know, that's interesting. That's something I'd have to think about. A lot of this stuff is really abstract. Anyways, what was the other question? There was a lady that had a question. Mary, was it Mary?
Now I have a question for Big Blue. Would that answer lie in the 10 square miles of what you just posed, please?
The state of Arizona is a fiction. The Republic of Arizona is a fiction. DC is a fiction. There are no latitude, longitude for those fictions.
Well, the Supreme Court has ruled that the boundaries of the District of Columbia expand as necessary. I'm not sure that it's relevant because the boundaries of the District of Columbia expand as necessary throughout the states of the Union. In the Kavanaugh hearings, they asked Kavanaugh when he was appointed to the Supreme Court. I think it was Lindsey Graham that asked him, "Can we go after a U.S. citizen in Afghanistan?" They're presuming you're a fiction. Okay, that's all fiction of law stuff, and so you have to defeat the fact that are you a fiction? It's latitude and longitude. I'm not sure that would be relevant, but and that's what the identity hearing is all about. Is you're defeating the issue of whether or not you're a fiction of law. And
there was a guy that flew into LAX, and while in LAX, he got arrested on a federal warrant. And we made that demand was made to show where in the United States the offense occurred, and they let him go, and he flew away.
Oh, that's interesting. That's interesting. That's certainly food for thought. That's definitely food for thought. Thank you for bringing that up. That's really interesting. Okay, well, that's interesting. At any rate, Gail, did you have anything else? Mary, Gail, Storm?
Yes, thank you. Thank you. I'm so glad to see you're here and back. And I was praying for you. I just want to say that. And as far as claiming fraud, I heard the word fraud. Wouldn't it be more, I guess, behooves is, I don't know. Wouldn't it behoove me to say unjust enrichment instead of stating fraud, without having to prove the aspects of fraud, even though it is fraud, but just due to the fact that you can't find remedy? Is that where I'm failing to see this? I need clarification on the difference between stating the facts of unjust enrichment versus fraud, if you will, please.
Well, actually, unjust enrichment's hard to prove. How do you know? How do you know that they're going and accessing that Treasury Direct account and getting money out of it? Have you got documented proof? Okay, because they're going to want to see that. They're going to want to see hard evidence that you got proof. Otherwise, they're going to just blow you off. And so fraud is easy because it's all block capital letters, and so that's easy. My attitude is I like to make the easiest argument I can that's going to work for me. And the illegal search and seizure. They went and searched the database. They didn't have authority. I didn't give them permission. And so where's their authority? They didn't have a search warrant. They haven't produced a search warrant. If they haven't produced one, then it doesn't exist. The court has to presume that. And so, that's easy to do. And so, but trying to talk about some commercial transaction, what you're doing is you're putting yourself in that venue. And I don't want to participate in that. That's why I tell them that they can take the fake money and put it up the rectal orifice. I want nothing to do with it, and because again, it comes down to clean hands under equity, because these are all courts of equity, and there's a clean hands doctrine. If you participate in the fraud, then you can't claim fraud.
Anybody How would else? One unwittingly and unconscionably participate in a fraud if it was through forced, under duress, threat, coercion, and threat?
Well, it's always like that, but until you tell them that are you coercing me and all that, then they're gonna go ahead and do it, and the burden's on you to object, and that's why anytime I was being when they arrested me, they would ask me questions, and I say I don't answer questions. I don't answer questions. I said that all the time, and after a while, I quit asking. But I just tell them I don't answer questions. So what you have to do is you got to basically refuse to answer their questions. If you answer their questions, what do they tell you? They tell you that anything you say can and will be used against you in a court of law. And they're not lying.
Wish I would have known those 5 words. I do not answer questions a year ago. Thank you.
Yeah, no problem. That's actually something I learned from a friend of mine recently, because that's what he said, and I was kind of surprised that they kept answering questions a few times, and after that they went away and left him alone because he didn't answer questions. And you can't lie to them, because that's obstructing justice. They'll charge you with some fictitious charges. So you just say, I don't answer questions.
You answer questions, Glenn?
I don't answer questions.
Coming from somebody who calls himself Joel or Jack Ask. That's what Glenn, that's what Joel calls himself. He's self-defense. Jack Ask.
No, it was asshole. Asshole.
Okay. Can you hear me?
I can hear
Glenn?
you. I can hear you.
You said you don't answer questions. You had already been arrested, right?
Yeah.
Because in 2005, under Salinas versus Texas, if you're not arrested, they can use your silence against you. It's only after you've been arrested can you invoke the Fifth.
May
Actually,
I? There's a lot of feedback.
You can arrest.
Before
you can
anybody-
invoke that at any time. If they're stopping you on the side of the road, it's an arrest. You're not free to go.
Yeah, that's a detain. A detain is considered an arrest.
Have you read Salinas versus Texas?
I'm not going to argue with you. The bottom line is that they stop you, you're not free to go, and I haven't read it, and I'm going to tell them I don't answer questions, and none of your damn business.
Well, they have to have RAS, reasonable articulable suspicion, okay? And that if they don't, it's like okay, you said that when they detain you, basically, yeah. So I just asked them, am I free to go? And then if they tell me no, then I say, just I'm invoking all my rights, and I'm very kind, very nice, and damn sure don't get smart with them, because I've watched them kill a lot of people.
Yeah, there's no
Sean
use.
Paul Reyes, from Long Island Audits, one of the best. Never gets irate, never yells, hollers, or anything like that. Just he's won how many cases now? I think about 12 or 13. I yield. I'm having some feedback.
Yeah,
I may, please.
Being detained is an arrest. If you're not free to go, that's an arrest. I don't care what they want to call it. That's an arrest. And there's court cases to talk about it. Yes, Mary.
Well, that's why I ask them. Yeah, ask them. If I'm not free to go, then that's when I invoke my rights. If they're holding me, then I want to know, can they articulate a crime?
There's no law saying you have to talk to them. Anyways.
Yeah, you do them kind of things, and they just, they pull you out of your car, throw you on the ground, kill you. I watched it. Hundreds of YouTube videos. Thousands.
I lived it.
They'll kill people.
If I may, please, if we can all unmute ourselves, if we are not directly speaking, every single one of us, there's a lot of feedback, and it's due to 2 or more unmuted mics going on live at the same time. Currently, I can hear a lot of feedback. Thank you.
Okay, well,
Glenn, can I ask you a quick question?
Sure.
Sorry, I got in here late. What was the reason that they arrested you?
Sorry?
I was just asking, what was the main reason that they arrested you?
Well, you saw the warrants, right? I mean, I'm not sure why that's so confusing.
I got in here late.
Okay, well, if you go back, you'll see where I did a motion to quash the warrants, and the warrants are attached to the motion. 3 felonies: terrorism, terroristic threat, and organized criminal activity.
Oh,
And
okay, okay.
they
I'll
dismissed
look
all
back.
of them.
That's great.
Hey, Glenn, was there ever any time that they wanted you to take your YouTube channel down or
No,
requested
they
that?
never said anything about it.
Nice. Good.
And I told a lot of the people in the jail, the prisoners, about my YouTube channel.
Yeah, they don't want you to educate anybody. They want you to be a good worker, a good trustee.
Yeah, I never had any trouble with any of that stuff. Even the guards, the guards were always nice to me, and I never had any trouble. These guards, a jail is kind of like adult babysitting, and so the guards get frustrated. That's for sure, because there's a lot of people in there that don't know how to behave. But I never had any trouble with them. And I'd go and work, and I'd get some food, and I wouldn't eat the food, so I'd give it to other guys. And so I didn't mind helping out. I wanted to lose weight, so I'd tell them, if it don't kill you, it makes you stronger. so I lost about 30 pounds. And I was glad to just have a little break and do something different for a while, and get to go out and see some different scenery, even if it's inside the jail somewhere else. And so they liked what I was doing. They would, the guards, when we're doing tray running and stuff like that, the judge would see me, or the guard would see me, and he'd definitely, you come, and that kind of stuff.
Nice. Well, the fact that you were picked up in Albuquerque, that's not really a friendly place. There was shit that went down there that, that's not a nice place to visit, right? So I'm glad that you extradited back to Texas. But what I was told is that it was a big 12-hour drive, and you were going to be in transit for possibly, a couple of days, right? So the fact that you got to take flights and you were comfortable and you weren't mistreated is just a very big relief off my mind, because that's what I was praying for, that you would be treated properly. So
I
good to hear that.
definitely, I appreciate your prayers, and I'm sure that's that U.S. Marshal. I mean, he was really nice, and it was nice. It's when we were going through security at the airport, it reminded me, because the same stuff that goes on, because I never fly. I always drive because I don't like getting groped, and they grope me for sure. And so it reminded me why I don't like flying. But it was nice. We sat at the very back. He went and arranged that we got the very back of the airplane, and so we got the very back, and we were the first one on and the last one off, and I was in a rush, and I told him, I said, hey, as far as I'm concerned, these are bogus charges, and I am not going to give you a hard time, or I'm going to do anything you want me to do, because I don't want to add real charges to the bogus charges. So I helped him, and he said he appreciated that. I did whatever he wanted me to do, He stopped at a Whataburger and bought me a burger. That was great, having a real Whataburger and some unsweet tea.
My God.
No, that's perfect. That's the way that I had expected that you would be treated, because you're part of humanity, and that's just the way that all humanity should be treated, correct?
Absolutely. You know, the jails are a perfect example of man's inhumanity to man.
Yes.
So, I have an obvious question. Coming from Chicago, and we do have this thing called Hotel California, only because it's on literal avenue called California Avenue. We nickname it the Cook County Judicial whatever jailhouse, Cook County Hotel California. With that in mind, do you have any jailhouse hacks, like maybe shoe polish or tape, band-aids, glue, tape, anything, any jailhouse hacks that you learned while you're in there, including maybe pressing your pants or cleaning your shoes?
Yeah, you missed a murder, Mary. You said earlier we went into the kitchen and delivered all the trays. So, Glenn, are you ready for your joke now? Because I
had a thing for that too, but I kept my mouth shut, and I'm ready for this joke. Let's hear it, please, sister.
But no, Glenn's been here for 2 hours and some, so we want to let him go so he can come back and see us again real soon. But I'll go grab the joke, and you're going to relate, Glenn. It's worth the wait. Hold on.
Okay, let's hear it. Still waiting. You're going to tell us a joke, aren't you?
That's a joke. Hardy, hard.
No, I got it grab, and it's in my saved messages. I'm getting it.
Oh, you're going to find it. Okay. Okay, I'm not trying to be a pest.
Hey, Glenn, when you're done, check your private messages I sent you.
Okay, where are the private messages?
You don't have your private messages in a folder or anything? Okay.
Not really, unless you sent them to like one of my groups, Sovereignty International or something.
No, I'm not doing that. If you click on my name, it'll say send message. Click on that and you'll see it.
Oh, okay. Well, let me find it.
And also, I did a little digging. Do you know if the governor signed off in New Mexico to have you extradited to Texas?
Well, that was actually one of the things that was brought up at the hearing, because the on that document, that waiver of extradition, it said right on there that there was a copy of it going to be filed with the governor.
Well, from what I found, the governor had to sign off on it in order for it to happen.
Oh, really?
Sorry, I missed that last one. In order for it to have what? Glenn, I'm sorry. Can you please unmute your mic, please? Because there's a lot of feedback.
You mean
Michelle?
mute my mic?
Yes, mute. I'm sorry. Yeah. Michelle, what was that term you just used? With the governor?
In order for a out-of-state extradition to occur, New Mexico governor had to sign off on it.
Yeah, and Witt had 2 witnesses too, I thought.
Is that because they're intending on foreclosing on an estate, aka the minor estate?
No, it has nothing to do with that. It's because it's interstate. And because he was incarcerated in New Mexico, he was property or liability to that governor of that state. And that governor had to sign off on releasing him to another state. That's what I found out.
Thank you.
Yeah, that was basically what was implied in that waiver of extradition.
But you had to see the signature. Did the governor sign that paper?
No, I didn't see. There was nothing that I saw that had the governor sign it. It said, well, let me pull it up.
And it cannot be a rubber stamp, correct, Michelle?
Wet ink.
Thank you.
Is David on the call? I'll go back and look in my files because I sent David and I don't remember if I sent Lee documents, but I'll look. I think it's in there. Lee, did I send you the documents?
Yes, you did, and I forward that to Glenn's contact.
Okay, here it is. So, says I, GlennWinningham, Vernon, open court, do freely and voluntarily state that I'm the identical person against whom a criminal proceeding charging me with terrorist activity has been initiated in the county of Tarrant, state of Texas, and I further freely, voluntarily, without threats or promises of reward, agree to return to that county and state without legal process. I further acknowledge that I will be held without bond while awaiting the agent of the demanding state to take me into custody. I further acknowledge that I've been informed of my rights to legal counsel to require issuance and service of a warrant of extradition as provided in Section 31-4-22 New Mexico State, and my right to contest said warrant of extradition through a writ of habeas corpus. The waiver is not an admission of guilt. I agree to return to the demanding state with any peace officer who may be sent to take me for trial. See, there was no extradition. I waived it. So I'm not sure that the governor needs to sign it. It says here, I certify the
judge. That's a judge's signature at the bottom?
Yeah. I hereby certify the foregoing was executed in my presence, and that I informed the defendant of his rights to require the issuance and service of a warrant of extradition as provided by the laws of New Mexico, and his right to contest said warrant of extradition through writ of habeas corpus. And I do hereby direct the officer having such person in custody to deliver forthwith such person to the duly accredited agent of the demanding state, together with a copy of this waiver, and that the original hereof shall forthwith be forwarded to the office of the governor of the state of New Mexico for filing. So I waived it. And in hindsight, maybe I shouldn't have. There's different schools of thought on that. But what's done is done. And now 40 days later, the thing's all dismissed. I might have been able to get it dismissed sooner in New Mexico. I might not have been. I don't know. But, I'm out now.
Yeah, okay. I just looked it up. It says because you waived extradition, the governor does not have to sign off on it. But if you didn't waive it, then yes, the governor has to sign off on it.
Okay. Well, I suppose that's about the end of tonight. It's 10:30, 10:37. So we've been going for about an hour and a half. Does anybody else? Oh, Lori was going to give us a joke.
I got it ready and everything. No waiting, but good info tonight, everyone. Good input from everyone. Thank you, Glenn. Okay, here's the joke. And this is called, and the siren has to be going by the zoo. Don't
check
ever...
your mics. A lot of feedback. Check your mics, please, everyone. Unmute yourselves, or mute yourselves, rather.
Okay, we all clear?
AC, thank you.
Okay, this is called Don't Argue with Donkeys. The donkey said to the tiger, "The grass is blue." The tiger replied, "No, the grass is green." The discussion heated up and the two decided to submit him to arbitration. And for this, they went before the lion and the king of the jungle. Already before reaching the forest clearing, When the lion was sitting on his throne, the donkey began to shout, His Highness, it is true, the grass is blue. The lion replied, True, the grass is blue. The donkey hurried and continued. The tiger disagreed with me and contradicts and annoys me. Please punish him. The king then declared, The tiger will be punished with 5 years of silence. The donkey jumped cheerfully and went on his way, content, repeating, The grass is blue. The tiger accepts his punishment. But before he asked the lion, Your Majesty, why have you punished me? After all, the grass is green. The lion replied, In fact, the grass is green. The tiger asked, So why are you punishing me? The lion replied, That has nothing to do with the question of whether the grass is blue or green. The punishment is not possible for the brave and the intelligent creature like you to waste time arguing with the donkey. And on top of that, come to bother me with that question. The worst waste of time is arguing with the fool and the frantic who does not care about truth or reality, but only victory of his beliefs and illusions. Never waste time on arguments that don't make sense. There you go, Glenn.
Could you send that one to me, please? I really, really, really appreciate that, aka joke.
I will.
That was just a topic of
Not really a
discussion
joke,
today.
But we don't want to argue.
What if you're asking a colorblind motherfucker, what color is the green grass? It's green to everyone, but yet in Chicago they have red fire hydrants and green ones too. What?
Okay, Glenn, you're gonna make me mute you, Mary. I love you, but you're gonna make me mute you. Glenn, thank you for coming. We'll research a better joke, but it was all so that we don't argue with anybody. That was the point. I hope you liked it. I'm trying to get better at the jokes. I don't know. I'll work on it. But I am so glad that you could with us tonight. You don't know how. So take care. I'll talk to you during the week. And thank you again. Night now.
Thanks for everything, everybody. Thanks for your prayers. And, I
thought it was funny.
I had a dream. That's another deja vu that happened because that's the little
is
joke
a
that you
different
just
color
said.
all around the world, right? But I won't argue. I won't.
Thanks, everybody. I had more deja vu just now. That little joke that Lori said, I dreamed about it, I guess. I can't remember, but I've heard that before. Anyways, thanks, everybody.
Don't get me going, Glenn. Don't get me going.
There you go. When are you going to come down?
I'll talk to you about it during the week.
Okay. Well, all right. Thanks, everybody, and thanks for your prayers and wishes, and it's a networking thing, and so we'll see you guys next week, same time, same place, same channel.
Hey, if we didn't hear from you, there is folks on here suggesting we do prayer vigils. So there you go.
There you go.
Don't get me going.
That has more power than most people know.
Why don't we close out with a prayer? Somebody? Anybody?
I would love to. Thank you, Mother. Thank you, Father, for emancipating this man, for his wisdom, for his voice, to be taught, to be heard, to be knowledgeable, to instruct. Thank you for your protection, your guidance, your decree, your affirmation over all of us, knowing we stand with you today. We love you with all of our hearts, every day, forever. And someone else, please.
Let it be done. See you guys next week.
Stay well.
Don't be late.